All right. Again, welcome to those of you who have just joined. My name is Liz Rinehart, and with me is Micah Wallen. I am a partner at Venable in our commercial litigation group, and Micah is an associate in our advertising and marketing group. And we are here to talk to you about local enforcement authorities, and specifically how those local enforcement authorities are turning their focus towards advertising law and consumer protection law. So to get started, why are we focusing on local enforcement right now? And it really is a timely topic because what we saw during the first Trump administration is kind of a surge of local enforcement activity. And there are many reasons for that, but I think one of the consensus is that it was because we saw something of a relaxing of enforcement on the federal level, and so the state attorneys general stepped in to fill that gap. And with them came sort of your bigger municipalities, your bigger localities started to become more active where they saw the federal government not really taking on the types of issues that perhaps these localities wanted some attention focused on. So as a way of an introduction, I think when most of us think of regulation and advertising law and consumer protection regulation, the first agency that comes to mind is the FTC. And there we may talk about Section 5, we may talk about the Lanham Act in terms of sort of the guidance that the FTC puts out on false and misleading trade practices. And we talk about some very aggressive rulemaking that's been going on at the FTC over the last 4 years. Again, I think the consensus is, oh, we lost the slides and we lost Micah. Should I pause for a second? So sorry, everyone. We're having a little bit of a technical difficulty. Just give us 1 minute. We'll try and get the slides back on. Thanks. So I'm encouraged that I see Micah again. Hopefully we can get the slides back up, but I'm not going to keep people waiting while we do that. I can finish up the last slide that we were talking about. So basically, as an overview, in many cases, we think of advertising regulation and enforcement as being part of the federal government's purview. When we have administrations, which we had in the first Trump administration, and we predict will also occur in the second Trump administration, that shift their focus from enforcement in the consumer protection context, what we often see is states come into that vacuum and fulfill that role. And many states have what you would call a mini FTC Act. So basically, state statutes that allow them either to enforce federal consumer protection laws or state laws that look very, very similar to the FTC Act or a similar consumer protection statutes. So this is all something that I think many of us in this space track and have a good familiarity with. I think what's often overlooked and what we're going to talk about today is the localities that have very similar powers as state governments and that are increasingly coming into that fray and filling that gap that the federal government may be leaving, or as a supplement to the federal and state actions that are occurring. And Mike is going to talk a little bit about those types of local enforcement powers.
So thank you, Liz. Sorry, everyone, for my momentary technology lapse on my end, but it's great to be here with everybody. As Liz said, I'm Micah Wallen. I'm in the advertising and marketing group here at Venable. And I'd like to talk about what we mean when we say local enforcement powers. Generally, where this is going to be coming from is it's going to be cities or counties. And then usually in both of those instances, it's going to be from district attorneys. But different cities also have different bureaucracy organizations within the city that also have power under these new laws. And one of the recent trends we've seen lately is that these laws are starting to come back. We've had large cities in America that have had consumer protection laws specific to the city for quite a long time. New York, Washington, D.C., and Los Angeles are definitely a few that go back to the 60s at least. But it's sort of maintained that way. We had Chicago join in 2008, but it was sort of just previously was cabined to just those very large American cities with large population centers. But in the last 2 years, we've also seen Baltimore and now Philadelphia just a few weeks ago also join. And there's a very good chance that this is something that starts to spread, particularly as Liz mentioned with the administration changing and potential for federal government regulation to be reduced or curtailed or just put into a different direction. There's definitely a chance that localities start to step up to the plate and try and make up for that in the place of a federal government that's going to be less active in this space. So these two cities that have changed recently, both Philadelphia and Baltimore, we want to keep an eye on those. Baltimore, we're starting to see some activity. Philadelphia is so new that we're not going to be able to discuss any enforcement actions from them today, but we'll still give a breakdown later on and the new law that they pass and what it pretends for clients and businesses in the Philadelphia area. And in addition to these new cities being added to the cities with consumer protection laws, in California, we also have some significant state Supreme Court holdings and also some statutes passed in the last 2 years that significantly increase the power of local enforcement in California at both the county and the city level. So that's been a recent change to this field as well that leads us to believe that there's going to be a lot more local enforcement in the years to come than there have been in the years past. And while the majority of this enforcement has been city focused, it's normally cities passing these ordinances. It's normally the city's DAs doing the enforcing. It also can exist on a county level. We see this in Maryland, 2 specific counties that have passed their own consumer protection laws. And also in California, we'll talk later about this bill, AB 2766, but they also just gave a lot of enforcement powers to county DAs specifically, in addition to the city DAs within those counties, which is also a new development. And then Liz is going to chat a bit here about New York City's consumer protection laws.
Thanks, Micah. And I think it's important as we get into this sort of overarching high level view of locality enforcement and the laws in which localities can operate, that we do emphasize this is a very high level view. One thing I think you're going to hear from me and Micah a lot is that the risks here are that we are creating a patchwork throughout the United States of different interpretations, different laws, different regulators having their own interpretations of their own laws, and monitoring that and navigating is going to become more and more complex. And we only have an hour today, so we're going to take a very high level, but certainly to the extent you're interested in a deeper dive, let us know. We're happy to do that. But let's start off with New York City. So New York City Code has its own unfair trade practice prohibition. You can see it seems very similar, the language, no person shall engage in any deceptive or unconscionable trade practice. And it talks about all the different services and products. It's a quite a broad statute. And then what I really want to focus on is the enforcement, particularly the civil penalties. So we can go up to $2,500 per violation and then $3,500 per knowing and third violation. That's in addition to any sort of restitution and injunctive relief. So these are statutes that have teeth. And I think sometimes because they are not, they have not been the focus, or they have not been the city's priority up until now, people forget that. But these are statutes that can really, really amass some pretty high penalties quickly. And so if we move on to some enforcement examples on the next slide, starting with Maddie's Home Furniture and More. This was a recent lawsuit and basically talked about people failing to perform on their services. And I'm going to pause and let Micah actually explain it because I think he knows more than I do about this.
So Maddie's Home Furniture was the New York City brought this in this New York Supreme Court just in May 2021. And between 2015 and 2020, New York's Department of Consumer and Worker Protection had received over 130 complaints about Maddie's furniture stores throughout the city. And we use Maddie's Home Furniture Store as sort of a catch-all term. It was a single entity that actually had a bunch of different, 10 or 15 different furniture store names throughout the city, but it was all looped up in the same entity. And so they started investigating, and in their investigation, they allegedly found that the store was luring consumers with deceptive advertising about financial offers or financing offers that misled consumers. These were referred to in the slides here as these zero interest ads. It was also just routine issues of just receiving damaged products, not being able to make repairs, not being able to receive refunds. The DCWP's lawsuit alleged 3,927 violations of the city code. And they were eventually forced to pay $2.2 million in fines and customer restitution. And you can see on the slides how 250,000 was the customer restitution fund, but almost 2 million of it was these civil penalties. So as Liz was saying, these are not small potatoes cases. These civil penalties can really stack up. And the pattern that we see in New York is almost all, I can't stress enough the importance of the consumer complaint aspect. Every single story of this in New York, because there's many cases that we won't have time to go over today, but the pattern is always just, this is how many complaints we got. We investigated, got a judgment, spread it out to the complaints over and over. It's just 100 complaints, 150 complaints, judgment, spread it out to the complaints. So definitely be paying attention to the consumer complaints you're receiving if you're located in New York City, because very likely the complaints that are going to New York City's government are going to mirror what you're also seeing on your end, and that's going to be an important way to get ahead of things. We also have the City of New York versus ExxonMobil case. This is a case that New York filed a lawsuit against 3 different oil and gas companies and the American Petroleum Institute, alleging that the defendants had violated the city's consumer protection laws through allegedly systemically and intentionally misleading New York consumers about the impact of their products on climate and falsely representing that they are, quote, environmentally responsible companies developing innovative green technologies and products. The city's complaint alleged that the companies violated the CPL by affirmatively misrepresenting the environmental benefits of various fossil fuel products sold at their gasoline stations. They also alleged that they had engaged in greenwashing campaigns by creating a misleading impression of the role of renewable energy in the company's overall business. These greenwashing claims are a good example of what we've seen a lot of federal regulatory activity in recent years on. And it's also very well could be something that we see curtailed in this next administration, which is why these claims and specifically could be something we see from local enforcement. We see a rise of that coming from localities rather than from the federal government. The city, in this case, they sought injunctive relief, the civil penalties, attorneys' fees and costs. Defendants filed to remove to Southern District of New York to get it into federal court, and Southern District of New York actually rejected that bid. They rejected it on every count, and I wanted to go through them because this also serves as an important example of sometimes when you're sued by these localities, you're not always just going to be able to remove it to federal court and get access to these federal laws and federal jurisprudence. Sometimes you're going to be stuck in the state court that it's brought in. And the Southern District of New York rejected. They said the federal common law could not preempt the city's, quote, garden variety false advertising claims, which the court said did not implicate either federal interest in regulating environmental pollution of the U.S.'s foreign affairs. They also said that the federal officer removal statute did not apply because there's, quote, no causal nexus between defendants' work for the federal government and defendants' allegedly false and misleading advertisements. They also rejected a defense which the court had very strong words for. They did not appreciate this argument, but the defendants tried to raise an argument that the federal enclave jurisdiction, either based on the extraction, production, or sale of fossil fuels on federal enclaves, was something that would preempt this action by New York City. The judge was not a fan of this argument, and this argument in particular is why he awarded attorney's fees to the New York City attorneys even after remanding it back to the state court. And this case is still ongoing. We don't know what's going to be in the end. The New York also rejected an attempt to say that there was a First Amendment element to this, and thus be able to make it removable based on the Grable exception to the well-pleaded complaint rule. The court was not having that argument either, and on every count sent this back to state court. Another enforcement example we wanted to go over was the City of New York versus Berkeley Education Services. Defendant was a for-profit college with campuses in Manhattan and Brooklyn throughout the city. The New York City Department of Consumer Affairs contended in their complaint that it opened an investigation into Berkeley's conduct after, again, receiving numerous complaints from the public. We see this pattern again of complaints and then taking action. They claimed that in their investigation revealed numerous acts of misconduct and deceptive practices from Berkeley. The complaint alleged 6 different causes of actions seeking civil penalties, restitution, disgorgement, and injunctive relief. They were able to obtain $350,000 in restitution, but in addition to that, Berkeley also agreed to forego the collection of over $20 million in outstanding student debt that was owed to Berkeley. And that just serves as another example of, yet again, is that these are not small potatoes. Even though it's a city near you, and even though it'll be in state court, it can still end up being very costly. And the last case here is I won't try to pronounce that first name, but the first name versus Better Homes Depot. Purchase, repair, and resell homes in New York City. New York City's Department of Consumer Affairs sued them, seeking fines and an injunction against their deceptive practices. And in this holding, the court ordered defendant to distribute $526,000 among 36 consumer complaints. And this is actually one of the reasons we brought this in here too, is it doesn't always have to be hundreds of complaints they're receiving. We've seen New York go after just a dozen complaints. In this instance, it's just 36. It really doesn't take that many for it to sort of tip them off, and then they start taking action and can end up being very costly.
And Micah, I'm just going to jump in because we did get a question that I think is very relevant, which is, how do we know when the number of complaints is high compared to other companies? is there any comparative research about FTC complaints per year or other regulators? So I think what we've seen just in New York is that it really isn't an issue of whether the complaints are high, it's whether there's something in the complaints that catches the regulator's attention. And I think assessing that risk requires following what the particular regulator is publishing on, what they're making statements about, what kind of enforcement trends, and sort of reading those tea leaves. I'm not aware of any, and Mike, I'm not sure if you are, comparative research about this.
There could be some third-party research done on the FTC side, but I very much would highly doubt it that it's been done on the city level, these municipalities, and that's another issue with the local enforcement powers. Is a lot of the time there's just a lot less materials out there, a lot less resources to get a good grasp over what you're looking at. New York City is probably the one with the most visibility. Probably maybe it's between Los Angeles and New York City, but once you get out into these smaller cities, there's just going to be very little to go off of, especially with Baltimore and Philadelphia just now starting. It's going to be very hard to know, is 5 complaints too much? Is 50 too much? The pattern in the New York City ones they generally seem to be over 100 consumer complaints is what leads to an investigation. But that's why I also included this Better Homes Depot case in here, because there's just 36. And even in the Maddie's Home Furniture case, we had 120, I believe was the exact number, but that was over a period of 5 years. So that's just them receiving a few dozen a year. And they don't tell us how many they had received before they started the investigation, but it can be a small number of complaints, which is why looking at the content of the consumer complaint and trying to identify patterns is what is going to be key, because that's going to be the way to find out whether there are actual, as the FTC would call it, dark patterns, actual just like deceptive strategy that are repeatedly deceiving consumers, and that's going to be something that they keep an eye out for. And next, we wanted to talk about Los Angeles, the next largest city in this space that also goes back as far as New York City in terms of having a consumer protection law. And California has been at the forefront of consumer protection litigation for a long time. So a lot of these things will come as no surprise. I'm sure a lot of attendees today are familiar with the UCL, the false advertising law, and the CLRA, but there's been some very important developments in just the last 2 years in California that has changed the power of these laws when it comes to localities. And under the UCL, I'll briefly just read through the provisions. 17200, as used in this chapter, unfair competition shall mean and include any unlawful, unfair, or fraudulent business act or practice, and unfair, deceptive, untrue, or misleading advertising, and any act prohibited by 17500. So this also incorporates 17500, which is shorthand referred to as the false advertising law, or FAL. And the big difference between the FAL and the UCL is that the FAL does allow for criminal penalties, but of course the UCL incorporates that into the UCL. Both of these statutes are used fairly ubiquitously by prosecutors within California. The CLRA is actually not as relevant for our discussion today, because CLRA is a private right of action, so that's not going to be used by local prosecutors or local enforcement regulators, except for the extent of, persuasive court opinions and whatnot. But some of the important changes I wanted to go over in California is, the first is this bill that they just passed, AB 2766, which they passed it in January 1st, 2023, and I believe it goes into effect January 1st, 2024. So I believe it went into effect just this year. But what it does effectively is it just grants all of the powers that are granted to the state attorney general to make investigations, prosecute actions regarding unfair competition laws to the city attorney of any city having a population in excess of 750,000, to the county council of any county within which a city has a population in excess of 750,000. California's government code authorizes the California State Attorney General as the head of State Department to investigate and prosecute actions under the UCL and by extension the FAL. But prior to this bill being enacted, these local entities were not afforded the same tools as the Attorney General and district attorneys to investigate unfair competition cases. And California passed another bill as well that went into effect this past year, which allowed for local enforcement agencies and the state AJs and the city DAs to also seek disgorgement of profits under the UCL. And this is important because in AMG cap management versus FTC, the Supreme Court case, the Supreme Court just took away from the FTC their authority to seek restitution or disgorgement penalties under Section 13B of the Federal Trade Commission Act. And in addition to this, in 2020 in California, we had the Abbott Labs versus Superior Court case. California Supreme Court gave county prosecutors the ability to seek civil penalties based on conduct outside of their county. So now we've arrived through a combination of these different laws. We've arrived at a place where your local county DA in California has more enforcement power over you than the FTC, because they can get disgorgement of profits. They can get anything that counts as economic damages under these UCL and FAL, very broad and expansive powers. And we'll go through some specific examples of some enforcement actions brought in California. But another trend that we see is a lot of the times these county prosecutors work together, and cases are brought by 7 or 8 different counties that qualify. And it's not always just going to be you versus your one local county DA or local city prosecutor. Sometimes they can band together and it ends up being a very formidable regulatory force that you have to deal with. And now that regulatory force has a broader array of penalties at their disposal than even the FTC does. Two of the examples I wanted to go over today specifically, these are very recent examples, just from one's from October 3rd of 2024, one's from September 12th, 2024. The first one is going to be Albertsons and Vons settlement. Albertsons and Vons is a grocery store chain throughout California. They have 600 locations throughout the state. So not an insignificant company in any way in that area. And this was brought by an LA district attorney who announced a $3.9 million settlement of a civil law enforcement complaint that alleged violations of the false advertising and unfair competition law. The complaint alleged that Albertsons and Vons unlawfully charged customers prices higher than their lowest advertising price. Further, Albertsons had issues with inaccurate weights on the labels of their products. Some items sold by weight, such as produce, meats, baked goods, and other items had less product in the packages than what was displayed on the package label. Again, this is alleged. For those items, a grocer may only charge the product's actual weight. The packaging is not included in the overall weight. LADA's Consumer Protection Division brought this case, and this is another example of them working together. They brought it with the district attorney offices of Marin County, Alameda County, Sonoma, Riverside, San Diego, and Ventura counties. All of these counties worked together to investigate and prosecute this matter, and the end result was $3.2 million in civil penalties and $750,000 in costs and restitution. And I would also note that the companies did not admit any wrongdoing. It was cooperative with the investigation, and they are taking steps to correct the alleged violation and the underlying action. And another example I wanted to talk about was the Home Depot settlement that recently happened. This is just in September of 2024. Again, this was brought by an LADA. This time, he worked with San Bernardino counties, Orange County, Alameda, Sonoma, just 4 counties this time, but you can see that some of them are different than before. It's very hard to know who they're going to be working with at different times and whether your case is going to be something that's a one-on-one or whether they're going to pool together. That's something that also makes the local enforcement area a little bit more unpredictable than dealing with the more traditional state attorney general actions or the FTC. But in the Home Depot settlement, the complaint alleged that Home Depot charged customers prices higher than Home Depot's lowest advertising or posted price. They referred to this as a, quote, scanner violation, and that problem occurs when the price on the item in the aisle does not actually reflect the price of the item when you scan it in at the end of the purchase process. Under the judgment negotiated with Home Depot, San Diego County Superior Court signed Home Depot was prohibited from engaging in false or misleading advertising and charging an amount greater than the lowest price posted for an item. It requires the implementation of a price accuracy program, which adds more audits and trainings and eliminates price increases on weekend days. The judgment adheres to California's pricing accuracy requirements. And here we can see, in addition to these civil penalties and restitution, there's also an aspect of injunctive relief to this one as well. And Liz, do you know if we got a question that came through while I was going?
We have a couple questions. I'm trying to sort of sprinkle them in as we go, but I'm going to pause right here because I think this is our first CLE code moment. So for those of you who will be seeking CLE credit, the code is local 2024. That's LOCAL 2024. So one of the questions we received, Micah, how do we expect to see local ordinances enforced for practices of strictly online organizations? I think that might be a webinar in itself, or at least half of a webinar. But I certainly, my opinion is I think they're going to try. And to the extent they could have a personal jurisdiction hook, and these statutes are quite broad. And I see no reason why they wouldn't interpret them to include online organizations if they are affecting the people in the locality, which is, their mission.
I would agree. A lot of the Philadelphia law, the Baltimore law, they have provisions that are clearly aimed at, in this new time, these purely online e-commerce merchants, which is, a new development in the last 25, 30 years, which is, much more recent than some of these consumer protection laws we're seeing in New York City and Los Angeles. So that is definitely a focus in some of these new regulations, and they will definitely try and interpret it as broadly as possible. And you're also going to run into different cities are going to take different approaches on whether whether it applies to injuries occurring outside the state, outside the city limits, or within only city limits or the state limits, or even outside the state limits. They're going to be interpreting it in different ways and trying to be as broad as possible. So that's something to stay aware of. But I wouldn't say that if you're a fully online merchant, that really absolves you of liability, or at the very least, the threat of investigation in any of these laws across these cities.
No, I agree. So I think we're moving to Chicago.
I will hand it back to Liz to discuss the Windy City.
Thanks, Micah. So I think at this point, we've noticed some patterns in the statutory language. So I'm not going to read it again into the webinar. But one thing I wanted to point out that actually isn't here is that the Chicago Municipal Code and the Consumer Fraud, Unfair, and Deceptive Practices statute not only has this explicit language, which again is very familiar, but it also incorporates as a deceptive practice any conduct constituting an unlawful practice under the Illinois Consumer Fraud and Deceptive Business Practices Act, or any section of this code relating to business operations or consumer protection. So here, what we have, it's actually quite clever, because what the municipal code does is it incorporates all the state consumer protection law. So to the extent that case law has developed separate from the municipal code, the municipality can take advantage of that and take advantage of that favorable case law if it needs to, as well as opening up a broader avenue for different types of enforcement actions. And so what has Chicago done recently? And as Micah mentioned in the beginning, the Chicago Consumer Protection Code has been around for quite some time. We've focused primarily on more recent examples, one of which being Chicago versus Sun Badger Solar. The crux of this case is the allegation that Sun Badger accepted deposits to install solar systems and then was unable to install them because of financial difficulties that the company was going through. And so had basically instructed its sales representatives to obtain large deposits, ostensibly to help with cash flow, but that the company knew that it couldn't fulfill the promises it was making to the customers. And then in response to customer complaints, Sun Badger claimed that the delay had to do with Chicago changing its permitting process, when in fact that had not happened. There had been no change. And so this case is ongoing, and all of the claims are for violations of the municipal code. and they are seeking $10,000 for each day of such violation, and existed and continues to exist. So it's seeking, and also seeking, about $425,000 in fines. And then the second case we have listed here, which is the DoorDash litigation. The litigation claims that DoorDash misled consumers regarding restaurant listings, fees, menu prices, and allocation of driver tips. This may sound familiar to those of us that are following this types of litigation. According to the website of this case, because this is one of the cases, and we haven't really talked about this, but often municipalities will retain private law firms to litigate these cases, either in tandem with city or county attorneys, or to simply litigate on behalf of the municipality. And so the law firm that is running this case has its own website. And apparently this was one of the first DoorDash litigations to be filed. But as we know, there have been many since then. So some of the allegations are inflated prices that are not disclosed to the consumers, allegations that the delivery fees changed once the consumer had progressed to the checkout page, allegations that there was what was called Chicago fee, and that misled consumers into thinking that the city required that fee, when in reality the city did not, and the city does not receive that fee. So the city did, the defendants moved to dismiss, and that was denied because the court found that there were factual allegations, and on a motion to dismiss, the court takes those factual allegations as being true. And so the case is in discovery. And I think these are two great examples of how these cases don't just go away on motions to dismiss, even in federal court, right? The DoorDash case is in federal court, and that court still found that the city had pled enough under both a Rule 8 and a Rule 9 standard in order to survive the summary judgment, the motion to dismiss standard. And as we all know, discovery can be very expensive. So it's something to think about. And then the last case we're going to look at for Chicago is City of Chicago versus Purdue Pharma. And I wanted to include it because I think, and we'll talk about this a little bit when we talk about Baltimore, but when we think of these litigations against pharmaceuticals, I think we often think about state law claims, but here they've also brought one under the municipal code. And basically the allegations are that defendants disseminated misleading marketing materials and sent their sales associates and sort of doctor representatives out to extol the benefits of opioids, even though allegedly there were counterindications and dangers that the company was downplaying. And so the claims are actually brought under the municipal code, and I'm going to go ahead and tell you which ones those are. It's deceptive business practices, engaging in unfair business practices, making misrepresentations in connection with the sale or advertisement of goods, and also seeking to recover costs that the city has expended in relationship to these violations. So again, I think a lot of times we think about this in terms of even state common law, but here we have a great example of a municipal code forming the basis for these claims, and they've survived a motion to dismiss. So with that, I think we're going to go to Washington.
Yes, to Washington, D.C. And I noticed one question too that we hadn't gotten to yet about where the majority of complaints are being logged, submitted by the complainant or the FTC specifically. And that's an important note. While there are plenty of complaints that are logged with the FTC specifically, and we would definitely always recommend monitoring the FTC complaint system, these cities and these DAs and these consumer protection divisions in different counties and different cities we've discussed already, they all have direct platforms for consumers to submit complaints. So these are going to be filed directly with the city, sometimes directly with the county, or directly with that DA's, that specific division of the city's county focused on consumer protection. They're going to be receiving these complaints directly. I've also seen cases, once they start receiving complaints, they don't just limit it to the ones they have. They'll go check the Better Business Bureau. They'll just go surf online. They'll, of course, look at the FTC's complaints. So the complaints are initially going to be what triggers them to look is going to be complaints they're receiving directly to their office in their city from consumers in their city. But once they catch wind of if they think they catch wind of a pattern, they're going to look for any complaints wherever and whenever they are.
And I think the takeaway there, Micah, is that, and not that anyone wouldn't, but like take these complaints seriously. If you get an email or a letter from a locality saying, giving you an opportunity to kind of explain what's going on, take it seriously, put forth a full explanation of why you think what you're doing is appropriate, and then, hopefully they'll be reasonable. But
And another note as well, we see this in the way New York City enforces their laws. A lot of the times in these cases, they will list out a specific number of violations, and it'll be a number like 8,362 violations. And that's because that's how many times they have specific evidence or instances or reports of that a violation occurred. So it's not always, going to be something like a specific advertising campaign that you're running that they're going to have a problem with. They will get as granular as possible to literally just narrow down to the specific transaction evidence that they have that somebody was deceived. That will go through Washington, D.C. This one is, we'll try not to spend too much time on this because this is a little bit bending the rules a bit, because even though D.C. is a city, it also operates sort of effectively like a state. So it's a little bit, the DC Attorney General and the DC prosecutors are a little bit more like what you see traditionally at the statewide level. But I still think it's important to bring up because DC often gets overlooked, I think, as a consumer protection area of law. DC has one of the most plaintiff-friendly, prosecutor-friendly consumer protection statutes on the books around the country. What sets it apart from the rest of the country, and it's referred to as the DC Consumer Protections Procedure Act, so we'll call it CCPA for short today. One of the things that sets it apart is while it lists out, I believe it's 26 different specific violations, it doesn't limit it to those 26 violations. It also has a catch-all of it can be anything deceptive. But all you have to establish is one prohibited act was committed. And that's, quote, whether or not any consumer is in fact misled, deceived, or damaged. The consumer does not have to allege harm. They do not have to have lost money. It could be a harm of your company said you had a product, and on my way home from work, I stopped by to look, and you didn't. And that's a violation. There's no injury. There's no refund needed. No time was taken by the plaintiff out of their day. And it still would not matter. That's still, because it's a statutory violation of a prohibited act, then it would count. And that's something that sets DC apart from many different state laws and city laws in this area. And so I wanted to make sure we specifically flagged that. Another part of the statute that's very broad is, even though DC, they limit it under the CPPA to only merchants can be sued. The definition of merchant is actually much broader than it is traditionally used. It is anybody on the supply side of a consumer transaction, or anybody who at any point advertises or offers a service to somebody who could be labeled a consumer. And as we've seen with these other statutes, we have civil penalties here as well. These ones can be quite significant. They can range from $5,000 to $10,000. They also have the ability to get restitution, disgorgement, economic damages, as well as having powers to receive injunctive relief. And on the slide here, we have the first 5 of these instances that they bring up. But again, there's 20 something of these that get very granular and very specific, but also they don't need to be specifically one of these ones. They just listed these ones out. And so you can see some here are some of the ones we've come to expect, like misrepresent a material fact, which has a tendency to mislead. I notice they don't say that which is likely or reasonably likely to mislead, just a tendency to mislead. All throughout the CCPA, the language is written as consumer friendly as you possibly can imagine. Now, we wanted to run through a few examples here well of some of the enforcement tactics they've taken. The first one here is in the matter of capital arena title, which is a DBA for universal title and affiliates. The DC OAG's office launched an investigation, and they allegedly found financial incentives that Universal provided to real estate agents by offering them discounted ownership interests in spin-off companies. and that this was leading the agents to aggressively steer their home buying clients to the spinoffs for title insurance. So here we see again, there's a little bit, normally this would not be classified as a merchant because they are not offering directly to these home buying consumers, but they are on the supply side, and that's the eventual where this chain ends. And so they're still brought in under the CPPA. The OAG's case is successful in getting them $500,000 from them. And this is also just the latest act in a series of cases that they brought in an industry sweep where they received over $3.2 million in penalties against 4 other title insurance companies as well in just this past August. Another case we wanted to bring up was the DC versus Solo Funds. The OAG announced a settlement just recently over interest rates that they found that their interest rate cap of 500% APR on average far exceeded the district's 24% cap on interest. Solo's platform was based on a model in which individual consumers lend money to other individual consumers. In return for the loan, the borrowers were required to pay a percentage of the loan as a tip to the lenders. Solo also solicited borrowers to pay a percentage of the loan to the company as a donation, in quotes. This settlement also, similar to the other one, builds on OAG's work to go after what they view as predatory lending in general. They recently received a $4 million judgment against Elevate Credit Incorporated. They had a $2 million settlement that they reached with Opportunity Financial. These are, again, just to reiterate, these are not always small potatoes cases, even in DC. They can go after very large companies, which brings me to this next one, which is an ongoing case. We don't know how this one's going to end up, but I included this case against StubHub because they're seeking, in this case, $118 million in restitution damages. They're alleging that StubHub is using what's called a drip pricing method. This is something that also was beginning to be emphasized with the Biden administration under junk fees. So this is another example of sort of what's happening federally, trickling down to these more local enforcement agencies and sort of directing where they're putting their efforts. And the allegations boil down to essentially there's an initial price at the beginning of the website. After a bunch of actual pages you go through and you get to the final checkout screen, that price is different than the original one that the consumer saw. They added up those price differences. They found that StubHub had sold 5 million tickets to DC consumers in the last 5 years. And that's how they get to their $118 million in restitution damages. And this is one of the largest cases we've seen out of the DC OAG in terms of seeking these damages. We don't know if they will be successful or what the eventual judgment, if any judgment there will be. But I just wanted to flag it as these cities, even though they're local, they like to take big swings. They're trying to put trophies on the wall. You're not safe just because you're a very large company. Some of the instances we've gone over have been like local furniture stores and things that see more, the little grocery chains in California. But they'll also just go after a national brand if they think they have a case against them and enough consumer complaints within their metro area. And with that, I will turn it over to Liz to deal with Baltimore City and Maryland. And Liz, you're still on mute.
Yes, I say let's talk about Baltimore. Before we move on, I do want to answer one of the questions. Do you need to be a complainant in the state, city, or municipality to file a consumer complaint? What if you know the same deceptive practices are going on in other jurisdictions? So from my perspective, Micah, I don't think you need to be a resident to file the complaint. Now, whether a municipality could bring a claim on behalf of a non-resident, I think would really depend on where we're talking about and what the law looks like and what the code looks like. But I see no reason why a non-resident can't file a complaint and get that investigation started.
Yes, and I would say specifically, I came across a case that was precisely that in DC's law specifically, because they do not. Another key part to that question is it matters whether you're going to be able to get removed to federal court or not. Because if you are, then you're going to have standing arguments that are available to you in the federal court system that sometimes can defeat these statutory standing laws where they just say there's an automatic injury, there's violation. In the federal court system, they'll say you can't do that. You still have to meet our standing requirements. So there has to be an injury. But if you're unable to get into federal court and you are stuck in a state court, that might not apply, and you might actually be subject to a complaint from somebody even outside of the city.
And I would say for removal, I don't know that we've seen this yet, but one thing I would not be surprised to see is municipalities and attorneys general coming together, right? Because that would prevent removal if an AG is bringing some of the claims. And so I would not be surprised if we saw that as a way to defeat removal to federal court. So moving on to Baltimore and Maryland in general, and I see the time. I'm going to try and go a little bit quicker through the Maryland information just because a lot of it is very new. And so we don't have the type of case law that we've been going through, but it's definitely worth flagging because what we're seeing certainly in Baltimore City is an appetite for litigation. I know those of us that are following the local news, the city just had a major trial victory in one of its opioid litigations. I think it was $266 million verdict. Now, that case, unlike the Chicago case we talked about earlier, was brought under Maryland state law. So public nuisance, negligence, the Maryland Consumer Protection Statute, and the Maryland False Claims Statute. Now, however, Baltimore City has passed its own consumer protection ordinance that could open up a whole other avenue for bringing these types of claims. So similar to what we've seen, it prohibits a person from engaging in unfair, abusive, or deceptive trade practices. It is authorized by the state consumer protection statute, which allows jurisdictions like Baltimore City to enact these types of local consumer protection laws. Now, and it is limited to Baltimore City. And because Baltimore City, in sort of a unique situation, does have a home rule, so it's limited in its jurisdiction. But as we've seen in the opioid litigation, that does not mean low judgments. That just means they're going to focus on Baltimore City. So we're going to be watching this very closely. I think we're going to see much more activity in the coming year. And then moving a little further south, we've got Montgomery County, Maryland. Again, list those very familiar 26 deceptive, unfair, and unconscionable trade practices. There are some specific ones that are, I think, not, perhaps not unique to Montgomery County, but worth mentioning, related to the ways in which internet services are provided, protections for domestic workers, specific requirements for gasoline stations. And so any complaints within Montgomery County go to the Office of Consumer Protection, and only the director of the Office of Consumer Protection can bring an action. We're going to see in Howard County, that is different, but in Montgomery County, it is limited to the government bringing that action. So what has Montgomery County done with its power? So I think Montgomery County is a great example of this mix of consumer education as well as enforcement actions, right? And I think we see a lot of that. We see a lot of that in the county space, right? So certainly homeowners and home improvement is a big area of focus for a lot of localities. I think that's an area where they feel very comfortable. And so we're going to continue to see those types of actions, even as they are expanding into the types of things that Mike is talking about, like junk fees or more technologically based consumer protection actions. There was also a warning about forced arbitration clauses, in particular related to Jiffy Lube locations and receipts that included arbitration clauses. And here is a great example where the subject of the investigation changed the practice. And that is an important thing. I know we've been very gloom and doom throughout this hour, but in my experience, a lot of the localities are willing to work with the targets of their investigation if the target of the investigation is willing to work with them. What we hear over and over is, we're looking for compliance. We're looking for compliance. So, to the extent that's feasible, to the extent you want to engage in a communication and you have representation that has a good relationship, we would certainly encourage that. And then again, it looks like Montgomery County is definitely keeping that focus on home improvement. So moving to Howard County. So Howard County, very similar to Montgomery County. It has its own Office of Consumer Protection. I believe in the past year, it has become a standalone office, which, to me, symbolizes that the county is investing more in the Office of Consumer Protection. Howard County is a great example of an office that sort of hosts educational events. They have sort of opportunities where you can get information and talk to the staff about things like landlord-tenant disputes and other types of sort of consumer-related issues, financial issues, and things like that, which I would really encourage people to take advantage of. Like, these are ways to avoid getting into their crosshairs, or if you end up in the crosshairs, you've got that great relationship that you can remind them of, and hopefully you can come to a more of a compromise rather than an enforcement action. And as I mentioned, the big distinguishing feature with Howard County is that it does permit consumers to bring private rights of action. And with that, Mike is going to go back up north.
And I will be brief on Philadelphia because this law just was signed by the mayor just 2 months ago, so we're not seeing enforcement on this yet. But there are two things specifically I really wanted to highlight. One is that this law actually goes farther than Pennsylvania's consumer protection law on the books. There are three specific provisions it deals with that the state law does not deal with, which is disclosure of certain material facts in advertising, use of statements that rely on exaggeration, innuendo, or ambiguity, and specifically terms and conditions governing subscriptions of products or services. These are specific callouts that are not in the Pennsylvania Consumer Protection Statute. So this is clearly Philadelphia, identifying the law in the books and wanting something more pointed, which I think indicates where their first targets will be and what their primary focus is going to be on, at least early on. And another thing I wanted to highlight as well about this is that previously, under the state consumer protection law, only the state AG and district attorneys could file actions on behalf of the government. Now, though, under the PCPO, Philadelphia's law department can also bring their own actions, which is an entirely, they were not able to do so previously. So that's an example of a locality really going farther than the state that it's in and really changing what liabilities and investigation threats or chances or risk you're facing in these different states. In some states like California, we see the broadest regulations at the very top of the state. So it's more so about whether localities have the ability to enforce it. But if we see more city ordinances getting passed in coming years, we could arrive to a place where these cities are going farther, getting out over their skis compared to their state, and actually really significantly changing the risks that you're facing.
So with that, in our last minute, just some summary key takeaways. I hope that this past hour has convinced you that local enforcement is a powerful regulatory tool. It can be costly and expensive, and it is most likely going to become increasingly relevant within, particularly in the next Trump administration. So, Micah, what should they do?
Well, one thing is also take down the CLE code. We'll give it one more time here at the end. It's got to be local 2024, not capitalized, just local 2024. And I really just recommend staying up to date on your local county, your local city. I think when I looked at California, there was at least 16 different counties that qualify under the new law that just went into effect this past January. So this is a changing landscape. Different counties, different cities are making moves at different times. So stay up to date. And also very much check the consumer complaints that are going into these cities or that you're receiving so that you can have an indication of what complaints these cities are indicating if it's not public record.
Great tips all. And if you have any questions, we are here for you. We're happy to answer them. And we really appreciate you taking your time out of the day and talking with us about locality enforcement. Thanks so much.
Thank you.